Hello and welcome to this one of a series of online seminars given by members of the family team at Dean's Court Chambers. I am Peter Rothery. I'm a family practitioner specialising in child protection work with over 25 years of experience. The question posed in the title is whether witnesses, rather like miracles, have to be seen to be believed. Does a judge need to be able to see a witness in the flesh in order to assess their credibility and their reliability? The question is brought into sharper focus by the need for remote working resulting from the coronavirus pandemic, but discussion about the significance of demeanour in the appraisal of a witness's evidence has been an issue of controversy for significantly longer. Like me, you may well have heard the argument deployed in court that a fair hearing cannot be achieved remotely because the court is unable effectively to assess the witness's evidence. The judge and the witness need to be in the same place so the judge can see the witness and look her in the eye. This argument, though not always successful, was at least in part the reason why in Re P, a child remote hearing, the President adjourned a case of fabricated or induced illness. In doing so, Sir Andrew Macfarlane said it was a crucial element in the judge's analysis of the case for him to be able to experience the behaviour of the parents, not just when they gave their evidence, but as they watched the rest of the case unfold too. At first blush, that may seem obvious. Many lawyers would regard the assertion that the effective assessment of credibility absolutely requires a court to see how the witnesses give their evidence as a statement scarcely requiring any further justification. But are they right? How far does the way in which a witness gives their evidence really affect the credibility of its content? Justice personified is a woman bearing a sword of truth in her right hand, holding the scales of justice in her left, and she is blindfolded, unseeing, impartial. We recognise the meaning lying behind that symbolism. The phrase justice is blind resonates strongly throughout the common law world. But when it comes to witnesses, we say that justice should not be blind. It's necessary to see a witness before deciding whether or not to believe them. Quite apart from the potential to disqualify the unsighted from judicial office, that depends on assumptions that certain responses or behaviours are objective indicators of truthfulness. This assumption is unsound. It is an approach which looks at judges as if they were polygraph machines searching for giveaway signs of dishonesty. Polygraphs are supposed to identify objective physiological signs which are indicators of truthfulness. Unfortunately, they don't work. They cannot identify effectively those who lie easily without any qualms. They may confuse a nervous witness with a dishonest one. Judges, I suggest, are no better than a polygraph when it comes to assessing demeanour. Why did Andrew Macfarlane say the judge had to experience the behaviour of the parents throughout the case in order to assess them? What is it that might be missed if the hearing were conducted remotely? If there really are signs of dishonesty that a competent judge ought to be aware of when assessing witnesses, what are they? A shifty-looking witness? A twitch when giving answers? Someone looking at the floor when they give their evidence? A witness who sits in the box with their fingers crossed behind their back? Or someone who is overly emphatic in tone? If a witness pauses and takes time to answer questions, does that indicate they are buying time to make up a convenient lie? Or does it mean that they are thoughtful and conscientious witnesses, giving their evidence carefully? It might be said you can't approach the appraisal of a witness with a checklist of things to tick off to determine whether the witness is credible or not. Assessment of the witness is a much more subtle process than that, which involves both experience and intuition, which in combination allows a judge to discriminate between the liar and the honest woman. What gives away the liar may vary from case to case, but a good judge can tell. But the fact that we can't readily put our finger on what signs of dishonesty a judge should be looking for when assessing credibility based on a witness's demeanour should lead us to question whether such an approach is reliable at all. The Judicial College, responsible for judicial training, has recognised for some time the mischief that can arise from reliance on demeanour. The Equal Treatment Bench Book warns judges not to rely on demeanour because it depends on a whole set of underlying assumptions about how people will behave in particular circumstances, and those assumptions may not be valid. People are not homogeneous. They react differently from each other and follow different social norms of behaviour. Naturally, the Equal Treatment Bench Book is focused on avoiding discrimination and recognise that this is a particular risk when relying on demeanour. It cautions judges that research does not support demeanour as a reliable guide to appraising a witness's evidence. The problem is the assessment of behaviour or demeanour is essentially a subjective matter, which is inevitably based on the individual judge's own perception of what normal behaviour is. But expectations of people's behaviour may be particularly unreliable if people are from a different culture, or if they are not neurotypical and function differently from other people. There is a real risk of unconscious bias influencing a judge's subjective assessment of a witness. Plainly, expectations of normal behaviour, which are implicit in any consideration of demeanour, may not be reliable when we are in abnormal situations. That the courtroom is not a normal setting was recognised by Lady Justice McKerr in Riem Children in 2013. She sounded a warning to judges about over-reliance on demeanour. A judge should expressly say in their judgment that they have not relied solely on behaviour in the witness box in reaching their conclusions, the implication being that a failure to do so may result in a successful appeal. My own thoughts on this subject were challenged and developed in a case I did last year before Mr Justice MacDonald, Cumbria County Council and R. The court had to consider whether to change findings it had made about the cause of a head injury following a fresh account given by the father during the welfare stage. The account was given to an independent social worker during a visit to the family home, and the social worker was impressed by the way in which the parents presented when the account was given. The parents sought to rely on what they contended was the genuine nature of the distress they exhibited when their story was recounted. In fact, the new account was not accepted, and for good reason. But what MacDonald J. said about the approach of the court is significant and repays careful reading. Put shortly, it was the judge's position that it is what a witness says that matters, not how they say it. In appraising the evidence of a witness, the judge should focus on internal consistency, on the evidence's logicality and plausibility, what details were given or were not given, and whether their oral evidence fits with other evidence, including what the witness had said before, and on the other known or probable facts. Judges should not assess credibility by reference to the way in which witnesses give their evidence. Demeanour was no more important in deciding whether a witness was truthful than in deciding whether or not they were lying. And the point is the same whether the judge is looking at demeanour in the witness box or considering other people's evidence about how a witness behaved at a particular time. Sometimes in cases there is a suggestion that a person's reaction to an event, for example, the collapse of their child, was unusual and that adverse inferences are to be drawn from that behaviour. In placing weight on a person's demeanour in that situation, the same caution should be exercised as it is when considering behaviour in the courtroom as an indicator of reliability. The result of this analysis was that for Mr. Justice MacDonald, the fact that the parents had appeared to the independent social worker to behave convincingly when giving their new account was of little or no value, given the very substantial evidential difficulties that there were in accepting what they now said. In expounding this view, Mr. Justice MacDonald drew heavily on the civil case of the Queen on the application of SS Sri Lanka and the Secretary of State for the Home Department. That case was heard as an appeal from an immigration tribunal. The Court of Appeal made some quite trenchant observations about demeanour based on research reported in American law journals. Those observations are as applicable in the family court as in any other jurisdiction. It is usually unreliable, said Lord Justice Leggett, and often dangerous to draw conclusions from demeanour about the likelihood that a witness is telling the truth. But the Court of Appeal went much further and warned that research suggests that demeanour may actually diminish, not enhance, the accuracy of credibility judgments. The research referred to confirms that in the real world we do not rely on demeanour to detect deception as much as might be supposed. Most people decide whether to believe someone based on whether they are making sense. Is what they're saying logical, plausible, and consistent? That is why we test witnesses' reliability in court through cross-examination, to try and expose inconsistencies and lack of detail in accounts through close and careful questioning. The Court of Appeal highlights the same dangers identified in the Equal Treatment Handbook. Relying on demeanour may in fact lead to injustice. It increases the likelihood of judgments which have no rational basis, like the judge who says, "I heard evidence from both parties and I prefer the evidence of X," with no further reasoning as to why. Worse still, it could lead to judgments which are based on underlying biases and prejudices that the tribunal has. To avoid that risk, a judge has to concentrate on an analysis of what the witness actually says. That is the only objective and reliable approach. The judge should ask herself, is what this witness says consistent with the other available evidence in the case or not? This approach requires a judge, if not to set aside intuitive thinking altogether, at least to test their instinctive views against a reasoned analysis. It requires that a reasoned judgment which objectively justifies the conclusions reached is delivered. None of this is intended to suggest that remote hearings are anything other than an unfortunate necessity in the current circumstances. Experience shows that there are very many good reasons why in-person hearings are better and ultimately more just. My argument is that the assumption that a judge needs to see a witness in person when they give their evidence is unsound. It's based on an outmoded view of the reliability of behaviour and demeanour as an indicator of credibility, which the profession should set aside. It is an inexperienced advocate who makes submissions about a witness's demeanour when that is such a subjective matter. What is required is a dispassionate, objective, reasoned assessment of the content of a witness's evidence to determine whether or not they are telling the truth. If that, rather than the judge's interpretation of the behaviour of a witness, is the lodestar, then justice, dispassionate, impartial, and yes, blind justice will be better done.